Good morning, my dear friends. Today's topic is Volenti non-fit injuria, means damage suffered by the consent is not a cause of action. My name is K. Umeshwara. I am requesting you to subscribe to my channel as it motivates me to give more and more topics. We are discussing what is Volenti non-fit injuria and what is the limitations for Volenti non-fit injuria. Volenti non-fit injuria. What is the meaning? It means damage suffered by the consent is not a cause of action. Sufferer invites probable danger himself. He gives consent for the danger which may or may not occur. Where the sufferer is willing to damage, where the sufferer is ready to accept the danger, no injury is done. For example, people go to the motor car races. These races, there are risk of injury. But if something happened, they cannot claim compensation. Another example, A is a patient. Doctor told him operation is necessary. A gave consent to the operation. Thereafter, he cannot claim compensation. But if the doctor perform operation in a negligent manner, then he will be held liable. So important point, it is sufficient for the defendant to plead consent and he need not plead knowledge. Even full knowledge of the act which is dangerous doesn't necessarily render the act tortious liability if done voluntarily. Now we will take some case laws. Hall and Brooklands Racing Club. Motor car race being held at Brooklands. Track was owned by the defendant company. Plaintiff was the spectator at a motor car race. There is a collision between the two cars during the race and the plaintiff was thrown among the spectators and plaintiff was injured. It was held that plaintiff impliedly took the risk of such injury. The danger is common in sports. The spectator could foresee the danger. The defendant is not liable. Another example, Oldridge versus Sumner. The plaintiff was a photographer. He was taking photographs at a horse show. One of the horses belonging to the defendant ran furiously. Plaintiff was frightened and fell into the horse's course and he was seriously injured by the horse. The horse won the competition and it was held that defendants had taken due care and they were not liable. Third case, Padmavati versus Dugga Nayak. Driver was taking the jeep for filling petrol in the tank. Two strangers took lift in the jeep. Suddenly one of the bolts fixed to the wheel came out and jeep was toppled. Two strangers were thrown out and sustained injuries and one of them died. It was held that neither the driver nor the master could be made liable because it was a case of accident. The strangers had voluntarily got into the jeep and the principle of volenti non-fit injuria was applicable. In some cases, persons give consent to bear the risk of harm or damage suffered. But the consent must be free from coercion, undue influence, fraud, misrepresentation. If the consent is influenced by the above characteristics, then the plaintiff is entitled for damages. We'll take some case laws. R versus Williams. Music teacher. He was guilty of rape. He had sexual intercourse with a girl of 16 years age. He pretended the act of operation to improve her voice. Lakshmi Rajan versus Malar Hospital Limited. 40 years old woman noticed a development of painful lump in her breast, but the hospital during the operation removed her uterus, the hospital is liable for deficiency of service and negligence. Patient's consent for the operation did not imply. Consent must not be given to illegal act. It should not be act which is prohibited by law. Mere knowledge doesn't imply consent. Case laws. Person is drowning in a water. To rescue him, another person jumped into the water. While doing so, he sustained some injuries. He cannot claim compensation as he done the act voluntarily. Dan versus Hamilton. The lady, knowing that driver of the car was drunk and decided to travel by his car. Due to driver's negligence, an accident caused. As a result, driver died and the passenger suffered injury. She filed a suit against the legal representatives of the driver. The defendant pleaded the principle of Volenti non-fit injuria. It was held that plaintiff is not entitled to recover damages. Limitation for voluntary non-fit injuria. Certain exceptions in which the principle is not applicable, they are as follows. Rescue cases. In ordinary sense, rescue cases, defendant gets the benefit of voluntary non-fit injuria. But if the negligence on the part of the defendant exists, then voluntary non-fit injuria is not applicable. We will go for some case law. Haynes versus Harwood. Police constable suffered injuries in preventing the horses. He was on duty and due to the negligence of the defendant, horse came off. Voluntary non-fit injury does not apply. It was held that police constable can recover damages. In another case, plaintiff voluntarily waived, abandoned the right. Plaintiff cannot claim damages. Plaintiff's defendant's act is misconduct and deliberate. This principle is not applicable because the act is faced with the risk of death. In the Haynes versus Harwood case, the defendant's servant left a horse van in a crowded street. The boy threw stone on the horses. Horses began to run. Horses injured the women and children. Police rushed to the van and tried to stop the horses. Police suffered injuries. Police sued the defendant for the compensation. The defendant pleaded that the plaintiff invited the risk and suffered injuries. House of Lords held that defendant is liable to pay damages. Dangerous operation or hazardous nature of work in factories where the work it involves is risky and danger. The owner should take extraordinary risk. Employees are working with the machinery, they are working for their family, their food. They know that there are always dangers in their work. They should take utmost care. But employer also should take necessary care. In one case, what happened? Defendant was an employer engaged in the business of drilling and cutting rocks. He is using cranes to transfer stones from one place to another place and cut them in different sizes. Workers worked busily in their work. On occasion, crane slipped, stone fell on worker's head and he suffered injuries. Plaintiff sued the defendant for compensation. Defendant pleaded that voluntary non-fit injuria. He argued that plaintiff knew the risk and invited the risk. House of Lords held that knowledge on the part of the plaintiff was not sufficient. Defendant has to take due care and diligence and defendant is liable. An action based on the statutory duty. When there is a statutory duty upon the employer to provide safety measures for the protection of employees, he should take all reasonable and skillful measures. If the employer fails to observe the instructions of the Act, and he shall be held liable even though the workers work for their livelihood. Employer cannot seek the defense of voluntary non-fit injuria. Defendant is under duty to prevent. When there is a duty imposed on the defendant to take care of a plaintiff, this rule is not applicable. For example, in one case, prisoner is having a suicidal tendency. He committed suicide while in police custody. It is held that police officer on duty has to take care. He failed to take reasonable care. So, voluntary non-fit injuria is non-applicable in this case. Thank you.